Let's pray. Thank you, Heavenly Father, for conveying us here safely as we contemplate this very significant work for the nation. Guide those who are on their way, guide our discussions, and may it be to thy benefit. Amen.
Amen to that, Senator Gale. Thank you. Good to have you. Okay, so can we go into apologies? Any apologies for absence? I know we have a strong contingent online, and then we have both Senators Gale and Longmore in the House. Any apologies?
Miss Bingley, she apologized.
Senator Daly?
Yes.
Okay, Senator Daly. And?
Mr. Wilson.
Oh, Wilson. Who's that?
Marlon Wilson.
Oh, Marlon Wilson, yes. He has apologized also. And anyone else? No?
Dr. Guy.
And Dr. Guy. So those are the three apologies. All others are here, online and otherwise, yeah? Okay, great. Let me just do a quick opening welcome to all who are here. First of all, thank you very much, and thanks to those who are online. It's been a long hiatus, and regretfully so, because we would have wanted to be further ahead with this bill. Sorry. A number of reasons for that, which I won't elaborate too much on, but we've had some scheduling issues with Parliament. We've had some delays in reviewing the report and trying to reconcile before we get to the meeting. Reconciliation meaning the key administrative teams trying to sort things out where that is possible before it gets here for conversation and discussion. And then, of course, we had some breaks related to holidays and so on. But nevertheless, we are here. We should be on the tail end of just agreeing on the report, and I'm hoping that we can do that. Just for the record to say, remember now, after this, we have the debate, both the lower house and the upper house, at which point I'm sure the quest for perfection can be pursued even more vigorously. So as long as we don't perceive or see anything that is of major hindrance, I think we have to trust the system and the process to hopefully deliver a piece of legislation that will serve the people of Jamaica, which is what I'm anxious for. So I thank you again for your participation. Thank you for your patience. And I would like to now move straight into the reading and confirmation of the minutes. Okay, so can we then look at the minutes before us? That's the minutes of November 7th, 2024. That's Thursday, November 7th, 2024. Pages 1. Page 2. Three. Page 4. Page 5. Six. Page 7. Page 8. Nine. Page 10. Pages 11. 12, 13, 14, 15, 16, 17, 18, 19, 20, and 21. Okay. Any corrections? I'll try to keep my eyes on the screen just in case persons have their hand up. Otherwise, you can interrupt me. Okay, if there are no corrections, can I move for the adoption of the minutes, and then we move quickly to matters if there are any? Thank you very much. Senator Gale moves, seconded by Senator Longmore. Thank you very much. All right. Matters arising from the minutes, I would assume, well, if there are any matters arising, then please raise those matters now. Otherwise, I suspect we'll go right into the rest of the proceedings, which would involve some of the issues that were discussed here. So we could actually fold both into one. Are there any matter arising or matters? No? All right. So Mr. Edwards is online, and I'm assuming that it is clear enough for him to hear and to speak. Mr. Edwards, can you, sorry, you want to say something? You're going to lead. Okay, all right. So Ms. Kadian Birch from the Ministry of Health and Wellness is going to lead us in the conversation, but Mr. Edwards is also online. Right, so Mr. Edwards, you can provide backup support. So let me just hand over now, if there are no objections, to Ms. Kadian Birch to begin the process.
Good morning, Chair. Thank you. Good morning, members of the committee. So the proposal in terms of the way forward today is to look at the report, which would have been amended in keeping with the discussions and decisions made at the meeting held on November 7th. Additionally, I would like to remind the committee that at that meeting, the Chief Parliamentary Counsel was requested to provide an updated bill with all the amendments that have been proposed by the committee. And so that amended bill was received in November, and we, in terms of the technical team between the Ministry of Health, the Legal Reform Department, and the Chief Parliamentary Counsel, we have had discussions on it to ensure that it fully captures what has been discussed. So that was circulated yesterday. So the members of the committee chair would have the bill, the updated bill, which highlights the amendments that have been proposed in red. And
would have received it not in the format that we usually, in paper-based format. Are we going to go through that now, or are we going to stick specifically with the reports?
we're going to stick specifically to the report, and then where there are errors in the bill that are still unsettled, we'll draw the committee's attention to those matters.
So in following through with the report, we'll be able to identify those?
Yes.
Okay. All right.
And so to indicate that the proposed changes which were agreed to the report are reflected in the revised report.
In the revised report.
And they're colored blue.
Okay.
For ease of reference.
Colored, well, all right. I will take it as being purple in this.
Oh, okay.
Just to be sure that I'm not colorblind.
Just the ink running out.
Okay, so the first, I would invite the members to page 4 of the report.
Right, sorry. Because normally we read the report into the meeting, just to be sure that we would have gone through everything in the report and so that nothing is missed for the recordings. That would include any amendments identified and any changes that we would want to make as part of the proceedings. But just to be sure, Chair, that we are capturing the essence of the report itself for the recordings. Yes, that's what I'm accustomed to.
Okay, go ahead.
Okay, starting with page 1, which starts with the establishment, composition, and terms of reference of the committee. It outlines that, reminds the members of the House that on the 26th of January 2021, on a motion made by Dr. the Honorable Christopher Tufton, MP, Minister of Health and Wellness, after suspension of the standing orders, the House of Representatives passed the following resolution. Be it resolved that this Honorable House appoint a special select committee comprising the following members: Mrs. Marlene Malahoo Fort, KCJP MP, Mr. Morland Wilson, MP, Ms. Ken Rincia Morrison, MP, Ms. Crystal Lee, MP, Dr. Maurice Guy, TD, MP, Ms. Joyce Denise Daly, MP, to sit jointly with a similar committee to be appointed by the Senate to consider and report on the bill shortly entitled the Tobacco Control Act 2020. Members are further reminded that on the 12th of February 2021, on a motion by Honorable Kamina Johnson-Smith, Minister of Foreign Affairs and Foreign Trade and Leader of Government Business in the Senate, after suspension of the standing orders, the Honorable Senate passed a similar resolution and appointed the following persons to the committee: Senator Kavon Gale, CD, Senator Dr. Sophia Longmore, Senator Shireen Golden Campbell, Senator Janice Allen, and Senator Gabriella Morrison. Members are also reminded that on the 18th of February 2021, on a motion by the Honorable Edmund Bartlett, Minister of Tourism and Leader of the House of Representatives, after suspension of the standing orders, the Honorable House of Representatives passed the following resolution. I'll just pause if there's any changes. Okay, so continue. Be it resolved with reference to the Special Select Committee appointed by the House of Representatives on the 26th day of January 2021 to sit jointly with a similar committee to be appointed by the Senate to consider and report on the bill shortly entitled the Tobacco Control Act 2020, and that the name Dr. the Honorable Christopher Tufton, MP, be added thereto. Members are further reminded that on the 23rd day of March 2021, on a motion by the Honorable Edmund Bartlett, Minister of Tourism and Leader of the House of Representatives, passed a resolution enabling the committee to hold virtual and hybrid meetings. Members are also reminded that by virtue of a resolution approved by this Honorable House on the 6th day of February 2024, and on the 11th day of February 2025, the composition of your committee, as set out above, was made to continue in force for this session of Parliament, and we were empowered to proceed with matters that were before us from the stage reached at prorogation. A similar motion was approved in the Senate on the 2nd day of February 2024 and the 13th day of February 2025. And then into the introductory matters. Your committee started its deliberations on the 24th day of February 2021. We agreed at our first meeting that we would take a consultative approach by inviting members of the public through public notices placed in the major newspapers to make submissions on the bill, as well as writing to specific entities inviting them to make submissions. The notice was placed in the Sunday Observer and the Sunday Gleaner on the 20th day of February 2021. Some of the entities that we sought views from did not respond to your committee's request. We received and heard submissions from the following entities: the Heart Foundation of Jamaica, the National Council on Drug Abuse, the Ministry of Health and Wellness, Carreras Limited, Jamaica Manufacturers and Exporters Association, Jamaica Coalition for Tobacco Control and the Healthy Caribbean Coalition, Aston Center for Health and Society, Association of General Practitioners of Jamaica, the Vape Shop JA Limited, Caribbean College of Family Physicians Jamaica Chapter, joint submission from the Secretariat of the World Health Organization Framework Convention on Tobacco Control. So I'm highlighting that the word control after framework should be convention. And the Pan American Health Organization, the Ministry of Education and Youth, the Jamaica Union of Tertiary Students and the National Secondary Students Council, Jamaica Psychological Society, Corporate Accountability, Jamaica Psychiatric Association, Jamaica Chamber of Commerce, Boots to Go, Jamaica Hotel and Tourist Association. In addition to the 17 submissions from stakeholders, your committee received a total of 109 letters from operators of establishments expressing concern about the impact of the provisions in the bill on their businesses once enacted. The technical team that assisted your committee in its deliberation comprised representatives from the Ministry of Health and Wellness, the Office of the Parliamentary Council, the Attorney General's Chambers, the Legal Reform Department. We had a total of 22 meetings, the last meeting being on the 7th of November, 2024, as outlined in the appendix. Of the 22 meetings, 7 were fully virtual, 5 were face-to-face, and 10 were hybrid. Comments, I continue. Section 3, Overview. The Memorandum of Objects and Reasons for the Bill provides that the proposed legislation endeavors to introduce a legislative framework for the adoption and implementation of tobacco control policies in accordance with the World Health Organization Framework Convention on Tobacco Control, to deal with the control of tobacco and to take into account current market practices that relate to the advertisement and promotion of tobacco products and relevant products and smoking generally. It further states that the bill seeks to adopt the provisions in the Public Health Tobacco Control Regulations 2013 and augment these provisions to provide additional policy initiatives relating to the sale and supply of tobacco products and other relevant products. The bill is broken down into 11 parts, that is preliminary, administration, protection of tobacco control policies, notification, tobacco smoke-free environment, tobacco products or relevant products and sales, advertising and promotion and sponsorship, reports and information, enforcement, fixed penalty regime, and miscellaneous and general provisions. It also comprises the first, second, third, fourth, fifth, and sixth schedules, which contains list tables and outline, other, I think it should be deleted, and outline the detailed information pertaining to various parts of the bill. We noted that Jamaica is a party to the FCTC, which was signed in 2003 and ratified in 2005. We were advised that the guidelines for the implementation of the respective articles of the FCTC have been adopted by the Conference of the Parties, with which all parties have signaled their intention to comply. Your committee now has the honor to present its findings and recommendations. Okay, no comments. Okay. The findings and recommendations, section 4. One of the submissions your committee received was from the leading distributor and marketer of tobacco and tobacco-related products in Jamaica. The entity expressed general support for the current Public Health Tobacco Control Regulations 2013, but noted that some of the provisions of the bill were excessive. It outlined concerns for provisions related to graphic health warnings, public health officials not being able to invest in the tobacco industry, the details required for reporting of ingredients in tobacco products, and corporate social responsibility activities such as sponsorship and scholarships. We observe that the operators of establishments that sell tobacco products and relevant products express similar concerns. One of the issues faced by your committee in analyzing the arguments presented was trying to balance the rights of an industry that produced a legal product versus the health consequences to individuals and society from the use of the product. It was our opinion that the argument presented by the company regarding tobacco control policies could be credibly refuted. It was our position, sorry. Yes. And that was one of the amendments proposed at the last meeting. These arguments related to an increase in illicit trade as a result of excessive tobacco control restrictions, the loss of government revenue as a result of the illicit trade, and the engagement of the tobacco industry in CSR activities. We note that the side effects of tobacco use are more deleterious to society and individuals than the contributions that are made by the tobacco industry. Members of your committee learned that tobacco is implicated in the causation and/or severity of non-communicable diseases such as cancer, cardiovascular disease, diabetes, and chronic obstructive pulmonary disease. It will be recalled that the amendment here reflects the discussion at the last meeting where we had previously indicated that it was a direct result, and a question was raised as to whether we could say that as a matter of fact. And so the proposal was to amend it to reflect that it's implicated in the causation or severity of these NCDs.
Chairman, just to remind me, Ms. Birch, what's the difference in the color code between the yellow and your proposed blue that appears purple in my paper? Just to be able to follow.
Sorry, there are no differences.
There are no differences.
In the edits, the Parliament may have not taken off the highlights because we had highlighted to them some of the essential changes.
Okay.
But they have made the changes in blue.
Okay.
Yes.
All right.
Furthermore, it is well established in multiple sources that tobacco is highly addictive and increases vulnerability to mental ill health, while mental illness increases the likelihood of tobacco use and nicotine addiction. This is coming from a recommendation from the last meeting.
Sorry, you said this was a recommendation from... I'm just trying to ascertain the source to see while mental illness increases the likelihood. Okay. I would probably say whilst a diagnosis of a mental illness, perhaps, or I'm not, but it's not. I think we can go with what it is right now.
Can I just, right. So you want to just put some? Where would you insert that? Okay, but before you read the paragraph, can we just pause to recognize and welcome the Christian Moravian Primary and Infant School. There are 31 youngsters, 13 teachers, and 27 parents, I am told, who are here. Thank you very much for being here. Welcome. Okay, great. Thank you. Ms. Birch, you want to just read back that section with the insertion of the word some, please?
Okay. Furthermore, it is well established in multiple sources that tobacco is highly addictive and increases vulnerability to mental ill health, while some mental illnesses may increase the likelihood of tobacco use and nicotine addiction. May increase.
Okay, continue.
Okay. In respect of the contributions made by the tobacco industry to CSR activities, two stakeholders suggested that the funds used for these activities should be channeled, and was just a correction of the spelling, through the Culture, Health, Arts, Sports, and Education Chase Fund. However, we were advised by the AGC of the amended Betting, Gaming, and Lotteries Act, which requires that money that was once required to be paid over to the fund should be paid over to the consolidated fund. We therefore did not support the position expressed by the stakeholders in relation to the fund. One of the issues identified by your committee was tobacco use in youth and the increasing demand by youth for electronic cigarettes, e-cigarettes. It was revealed to us that the prevalence of smoking among male and female students between the ages of 13 and 15 years was the same as that of smoking by adult males and females. We are of the view that youth should be educated on the health risk of tobacco use. We are generally of the view that graphic health warnings are effective as they have a deterrent effect of communicating to tobacco users and non-users the health risks of tobacco use and assist current smokers to quit smoking. Okay. The specific recommendations. Your committee did not recommend that the following clauses be amended. And in reviewing again last evening, I noted that there is to be some adjustments to the numbering here in aligning with the updated bill that has been provided. So no amendments have been made to clause 5. Clause 11 should be clause 12. Clause 14 should be clause 13. Clause 16 is now clause 15. 17, 18, and 19. Yes. 22, 23. Well, 22 to 24, there are no amendments to those clauses. 26 to 25. 26 to 27, sorry. And so 26 to 37 is deleted to 22 to 24. Inserting 26 to 27 and delete 39 as it's now 40 to 41 based on the new numbering.
Sorry, I see a hand up. Is that Mr. Edwards? Mr. Edwards? Not hearing you. Your sound, we're not hearing you. I don't think it's your camera. We're seeing you, but we're not hearing you.
Is it on our end? We're not hearing other.
Not
seems
hearing
to be on our end.
Senator Golden either. Is there anyone who, is the system working? Not hearing you either, Senator Allen. So maybe we have a volume issue here with the system. Can we get the technical people to? Why are we having each other online chamber not hearing? Yeah. Are you hearing us? Can somebody just indicate?
I'm going to repeat 29 to 37.
Okay.
37, yeah.
You're hearing, but not able to speak. All right, we're checking on that. you want to continue and then
I would just want to repeat so
repeat,
that we're clear.
right, repeat, and then continue, and then when, if there's a issue, we can go back once the sound is working. Yeah, go ahead and repeat, Ms. Birch.
So your committee did not recommend that the following clauses be amended. Clause 5, 11 is deleted and replaced with 12. 14 is deleted and replaced with 13. 16 is deleted and replaced with 15. 17 remains. 18, 19 is inserted. 22 and 23 is deleted and replaced with 22 to 24. 26 to 37 is deleted and is to be deleted and replaced with 26 to 27. 29 to 37 is to be inserted, and 39 deleted and replaced with 40 to 41. Yes. Yes, we're to delete 21. No amendments were also recommended for the second to the fourth schedules.
Can we try again if someone online, if the sound is not hearing anybody?
So they're hearing us, but we're not hearing them.
Let me put a post in the
We're hearing someone now. Okay, I think yes, I'm here. Well, I'm hearing you on the laptop, but not on the central sound. We could, go ahead, Member Golden, let me repeat what you say. I know they're hearing us. I'm hearing you now via the laptop right here, but not through the central system. So maybe, go ahead. Miss.
declare as well as you, but I'm not sure what is the audio issue.
All right, let me hear from the system here, and I'll just indicate what is said until we try to sort the system out. I believe Mr. Edwards had his hand up first, and I see SG after. Mr. Edwards, you want to go ahead?
Because if we are making recommendations on the bill as is, then we have to stick to the original clause references. I know the Ministry of Health team is trying to help referring to what the numbering will become, but for the purposes of record, we need to speak to the changes on the bill that the committee is reporting on. The SG has raised a further question, which she can elaborate in relation to what is the intention. Are we going to be tabling a revised bill document, or is it that the current bill, we're just going to make references to the changes as several as they are to the original bill without submitting a revised document?
1 second, Mr. Edwards. Can you just turn the mic down for me, please? It's a little muffled. This is the parliamentary stuff now. Okay, go ahead. Go ahead, Mr. Edwards. Go ahead, Mr. Edwards.
Oh, yes, Chair. So what I was suggesting that the references that Ms. Birch has been making to the new numbering, that for the time being, we should just refer to changes being made to the bill that is actually before us. And then the question of whether that bill is going to be withdrawn and then revised bill be submitted is another matter, which I think the SG has commented on in the chat.
Okay. So you're saying that
For the time being, we just refer to the existing numbering of the bill before us.
Okay, let me hear from SG. SG?
Yes, thank you. Good morning, everyone. I don't have a difficulty with the proposal from Mr. Edwards, which is if we're just looking at the bill, then you should just be commenting on the bill as it and not speaking of renumbering and so on. But I wanted to understand, is it that a list of amendments are going to be tabled with the bill? Because I thought the reason the Parliamentary Council was asked to do a new bill, to revise the bill, update the bill, was because the intention would have been to withdraw the old bill and then table this revised bill, because it makes it easier to read rather than a very long, involved list of amendments that even to those of us who have been in the business for a long time, it's difficult to read.
Yeah, I
If
agree with you
so
on
if the
that.
committee, right, so if the committee is not going to be doing the list of amendments, then some of how the report, some of it can just be, and it's easily tweaked, very easily tweaked, but you don't need to be talking about the renumbering and so on, because that won't happen. You're not going to be doing a list of amendments, doing the renumbering. And at the end of the report, or somewhere in the report, the clerk can guide you, you would have to, the committee would then have to take a decision to recommend to the Parliament that in light of all these changes, the recommendation is to withdraw the bill that was tabled and to table this bill that will be in keeping with the recommendations of the Joint Select Committee. Thank you.
I'm with you. I'm with you on, wow, this system is, I'm with you on that. You need to turn yours off, I think. I'm with you on that, SG. I think it's more efficient. So why don't we proceed on that basis? You want to comment on that, Ms. Birch?
Yes, I was just consulting with the Legislative Council, who indicated that we could take that approach where the updated bill, which we had asked the CPCs, attached as an appendix, and then we seek to have the bill that has been tabled removed and this.
So that would then allow for some more efficiency in going through the report without having to try to clarify the numbering. So let's proceed on that basis, because I got a little confused there when you were doing the numbering. Didn't want to say it, but I was. All right, go ahead. Go ahead.
Clause 1, short title and commencement. Members of your committee note that...
Sorry, Chairman, please, I'm just asking that attention be directed to something I posted in the chat group in respect of a proposal. One of the proposed changes.
Can you echo it verbally, please, Madam?
I just, I have a question for the Learned Solicitor General in relation to the newly proposed clause 9.9, which places a burden. There's a typo there. R should be a burden.
Are we at that stage of the report? No, I don't think so. Can you just hold off a little,
all right,
Madam Minister,
very well.
Member, and then we get there, we do that.
Okay.
Go ahead, Ms. Birch.
One short title and commencement. Members of your committee note that an editorial change should be made to the provision to reflect the year 2025. Clause 2, interpretation. This clause provides the interpretation of key terms that are used throughout the bill. Based on the concerns raised by stakeholders, your committee wishes to make the following recommendations. So at the last sitting, we had looked at the definition of occupational activity, and the committee agreed with the recommendation made to amend the definition in relation to mean in relation to a person means the engagement or employment of the person in work in a commercial or non-commercial undertaking, and whether or not for compensation. Public place, we recommend that the term should be defined to mean any structure, facility, place of assembly, government office, or other place of general resort, whether or not payment is required for admission that is available to be used collectively by the public, including a space or a building of any type, regardless of the ownership of or right of access to any such place, office, or building. Members of the committee accepted and recommended that the phrase admission to which is obtained by payment should be positioned anywhere after the word including, to make it clear that it was not to limit the words before it, but to expand them. Relevant product, having accepted the recommendation of one of the stakeholders that clause 12.1 should be amended to include an electronic non-nicotine delivery system, ends, we recommend that the definition of the term relevant product be amended to include ends.
Excuse me, Chair, I have my hand up. Marlene Aldred.
Go ahead, SG.
Just in the definition of public place, I still saw some round brackets. Perhaps you don't want to just remove them.
Yes,
but that's in the report I have.
Removed. On page 7
yeah,
of
just,
the bill, the brackets at
right,
the end
just to say that the brackets will be removed. Okay, thank you.
Thank you, SG.
Secondary smoke.
Secondhand smoke. We recommend that a definition for the term secondhand smoke should be inserted to mean smoke or other emission from a lit or heated tobacco product or relevant product in combination with the smoke exhaled by a smoker. Members of your committee were advised that the wording of the definition would be refined. So at the last meeting, it was raised in terms of whether the definition could be refined to be clear in terms of causation in relation to secondhand smoke. However, in relation to secondhand smoke, there is no offense under the legislation in relation to secondhand smoke. Secondhand smoke is referenced in relation to clause 4 subsection 2 subsection C, which is the powers of the minister to prevent or minimize injury or harm to persons from the exposure to secondhand smoke. And therefore, we did not put forward any further amendment to the provision. In relation to smoke, members of your committee were advised.
Sorry, excuse me, Chair. I'm so sorry. So I'm suggesting, remember, this is a report by the committee. And so when it says we recommend, it means your committee. And in fact, I'm usually accustomed to seeing something more like that. Your committee recommends, but it's fine that it says we recommend. It then means, though, that that last sentence in round bracket should be deleted. So you delete the brackets and the words in the brackets.
Correct. In relation to smoke, members of your committee were advised that with the expansion of provisions relating to ends, there will need to be modification of the definition of the term smoke. We therefore recommend that the term should be amended to mean smoke means to inhale or exhale or hold or operate, as the case may require, a lit or heated tobacco product or relevant product producing an aerosol vapor or other emission. And the members of your committee agreed with the recommendation made to amend the definition. However, in consultation with the Chief Parliamentary Council and the Law Reform Department, we are now proposing, that is the Ministry of Health, a alternative definition to smoke to mean being in possession or control or otherwise responsible for a tobacco product or relevant product producing tobacco smoke or other emissions, regardless of whether or not they're being actively inhaled or exhaled. To repeat, smoke means being in possession or control or otherwise responsible for a tobacco product or relevant product producing tobacco smoke or other emission, regardless of whether they are being actively inhaled or exhaled. Because we wanted to ensure that it's the verb that will be easy to link causation in terms of the offense under the section for tobacco smoke. If there are any comments?
Okay. I see no objection, so let's proceed.
So can I make a suggestion then, Chair, in terms of your report? So after your first sentence that says members of your committee were advised, I would then suggest that it could continue to say that the committee was further advised that additional modification could be made to ensure that there is a link with, what did you say, Ms. Birch, causation and the offense?
Yes.
And then it would say, your committee therefore recommends that the term should read, and then you just set that out, and then you can remove what is here. I hope you understand what I'm saying.
Yes, S3.
Okay.
Any other comments?
Go ahead.
Tobacco industry. We recommend that the term be amended to denote means person operating as tobacco manufacturers, wholesale distributors, or importers and exporters of tobacco products and relevant products, and includes association, lobbies, or other individuals or entities representing such operators or persons working to further the agenda of such operators. And this was agreed at the last meeting, so we could remove what is in bracket. Before we move on from Clause 2, Minister, I want to highlight that recently, I think it was last week, we got a suggestion from the Bureau of Standards in relation to the definition of authorized officer. Currently, authorized officer is defined as to mean a constable, a customs officer appointed under the Customs Act, an inspector appointed under the Standards Act. And they're suggesting that in light of the new authority established under the National Compliance and Regulatory Authority Act, that it all the inspector C under authorized officer be amended to include an inspector appointed under the Standards Act and under the National Regulatory Compliance Act. So we put that to the committee. Yes.
Okay. I think that should be fine.
Any comments? Okay.
No comments? All right, proceed.
To Clause 3, object of the Act, one stakeholder suggested to your committee that Clause 3E should be amended to include an increase in the awareness of the public and/or public body about the addictive nature of tobacco products and relevant products. It was also recommended that the provision should take into consideration the need to educate, inform, and raise the awareness of the public about tobacco industry interference with tobacco control policies. Members of your committee agree with this recommendation in part, but express reservation regarding the reference to the tobacco industry interference. We felt that there was no need to include the awareness of the public about the interference of the tobacco industry with tobacco control policies, since Clause 7, subsection 1, subsection B would cover the issue. We therefore recommend that the following words or words to the effect be used in the provision. E, inform, educate, communicate, and raise awareness to the public. And we have in brackets here, and or any public body, following the discussions that awareness should also be raised among public bodies. The committee did not settle on that, so we seek the committee's position on whether to include and or any public body. So it would read, inform, educate, communicate, and raise awareness to the public and or any public body about the addictive and harmful health, environmental, economic, and social consequences of the use of tobacco products and relevant products, and about tobacco industry strategies in relation to public health policy for tobacco control.
Okay.
So
you had a point.
I was just stating that I think it should be included, and or any public body.
Okay. Other comments? All right, proceed, please.
Part 4, Administration. Clause 4, Powers of the Minister. Members of your committee recommended and accepted deleting the phrase "make provision for the development and implementation of" to be replaced with developed. Based on the suggested amendment to Clause 7, it is recommended that a new provision be inserted in Clause 4, subsection 1 to state that the minister shall cause to be developed a national strategy for tobacco control that includes provision for the protection of the public and public bodies against any undue influence by the tobacco industry. As a result of this change, we recommend the renumbering of the other provisions in the clause. Clause 4.1f, we accept the recommendation that the words "or advertising" that should not have been struck out in Clause 4, subsection 1, subsection F, be deleted, as it would be inconsistent to address the regulation of the prohibited activity. Clause 4.1f(2), your committee recommends that the provision be amended with the following words or words to effect: prevent or minimize injury or harm to the health of the users or exposure to secondhand smoke. I would like to draw, in light of the foregoing, the revised clause is as follows. I would like to draw the committee's attention to the revised clause, which is reflected in the report, needs to be amended to reflect what is actually updated in the bill. Because following discussions with the Chief Parliamentary Council, we noted that some of the matters listed under subsection 4.2 are matters which are to be prescribed in the regulations. So the CPC have made the relevant adjustments. So I will read the correct wording of the clause now, which is on page 11 of the bill. The minister shall cause to be developed a national strategy for tobacco control that includes provision for the protection of the public and public bodies against any undue influence of and interference by commercial and other vested interests of the tobacco industry. Notwithstanding the provisions of any other enactment and subject to the provisions of this act, the minister may prescribe controls in relation to the labeling, packaging, sale, or distribution of tobacco products and relevant products, so as to ensure that the user of a tobacco product or relevant product is not misled as to its quality, quantity, character, value, composition, or effect. 2, prevent or minimize injury or harm to the health of the users of tobacco products and relevant products. And B, by order published in the Gazette, prohibit the addition and use of any constituent or ingredient in the production of tobacco products and relevant products. 2, regulate any design feature of relevant products. And C, prevent or minimize injury or harm to persons from the exposure to secondhand smoke. And the other subsections have been removed to section clause 39 of the bill under the regulatory making powers of the minister. Any comments?
Okay.
Any comments? Clause 6, education and information. A campaign to be carried out in schools, etc. Having considered a recommendation from one of the stakeholders that places of entertainment, recreation, and sports are frequent areas where tobacco and tobacco products are used, we recommend that the provision be amended with the following words or words to the effect. The education and information campaign referred to in Section 5 shall be carried out in all schools and other institutions of learning and at all workplaces, sports, health, athletic, and recreational facilities available for the use of the public and in all communities throughout Jamaica. The words in brackets may be removed where it says members of your committee were advised of the further amended provision by changing initial lowercase t to capital T. Those may be removed from the report. Members of your committee recommended and agreed that health facilities should be included among the list of places where education and information campaign referred to in Section 5 should be carried out. No comments? No comments?
Chair.
Yes, go ahead. Go ahead.
Yes, just Patronus Seeley Brown from the Office of the Parliamentary Council. Just to go back to clause 4, 4.2b.1, where we speaks about the minister may, by order published in the Gazette, 1, prohibit the addition and use of any constituent or ingredient in the manufacture of tobacco products and not production of tobacco products.
Okay.
I'm suggesting that change. Thanks, Chair.
Any comments on that, or if not, we accept and move on? Go ahead.
Minister, I'm going to invite Mr. Edwards to take us through Part 3, Protection of Tobacco Control Policies.
Mr. Edwards, can you take us through Part 3, please, starting with Clause 7?
Thank you, Chair and colleagues. Part 3, Protection of Tobacco Control Policies. Clause 7, Policy of the Government in relation to tobacco control. Your committee recommends that Clause 7(1)(c), 2, and 3 be deleted, and that the provision at Clause 7(1)(a) and b be inserted as Clause 4(1). We further recommend that Clause 7 be redrafted to be a definition provision for the new provisions dealing with conflicts of interest and limitations of interaction with the tobacco industry by specified public bodies and specified public officials. Your committee further suggests that the following terms be defined in this provision. That is, appropriate authority, appropriate public body, interaction, parliamentarian, public function, public official, specified body, and specified public official. The proposed revised Clause 7 reads as follows. Appropriate authority in relation to a public official means the individual or entity that directly or ultimately has oversight of the official conduct of the public official. And as SG indicated earlier, had advised earlier, we'll be deleting all the words in square brackets that speak to how the committee arrived at these decisions. Appropriate public body in relation to a public official means a public body
that the public official is employed to, contracted to, or otherwise serves within. Interaction means a meeting or any correspondence between a public official and the tobacco industry, or other exchange between a public official and the tobacco industry that arises when the public official meets with the tobacco industry in a common forum. And there was an explanation that the committee was advised that the word common was used instead of business, which was in reference to a place that was not assigned or designated by either one of the entities, but a neutral place. Parliamentarian means a member of the House of Representatives or a member of the Senate. Public function means any activity performed a single time or continually, whether or not payment is received therefore, which is carried out by A, a public official in the capacity as such, or B, a person on behalf of or under the direction of a public body. The words in brackets to be deleted, which are explanatory. Public official means a person who performs a public function or holds an office of employment to a public body, or is a parliamentarian, whether the person is appointed or elected, whether permanent or temporary, or whether paid or unpaid. Specified public body means a public...
Chairman?
Yes.
Mr. Through you, Chairman, can you just remind me what burden is being placed on the public official so defined?
Yes, to Chair, to Honorable Member. This relates to the provisions that are restricting certain interactions between public officials and the tobacco industry, and also provisions relating to avoidance of conflict of interest by investment or other connections between public officials and tobacco industry. Minister. Which definitions, which terms will be used in the clauses that follow?
Just seeking a reminder, please. And in terms of current practices, for example, with the provision of donations for activities by known groups, what are the implications? Just seeking a reminder.
The implications are that there is, the bill is providing restrictions, specific restrictions in relation to interactions involving monetary donations, or I'm looking for the specific provision. Exactly. Now we're looking at what is to be numbered as clause 8.7, for example, and it speaks to restrictions on accepting direct or indirect funding from the tobacco industry, or entry into projects or partnerships with the tobacco industry, and such like endorsing activities of the tobacco industry which advance or appear to advance the interests of the tobacco industry. That's just one example of some of the restrictions that will apply to public bodies. And then in relation to the specified public officials, there is also restriction on participation in interaction with the tobacco industry. It has to be for necessary purposes. The wording is that the public official should only participate in interaction with the tobacco industry to the extent that is strictly necessary for effective tobacco control and enforcement of the laws. Because it is recognized that there will have to be interaction, because it's an industry. And therefore, there will have to be interaction between the regulator, public official, and the industry. But this should only be within a very defined remit, and that is interaction that will facilitate the effectiveness of the back control.
So may I just ask again, because when we are changing cultural context with a law, the law it doesn't change overnight, and I'm just suggesting that the ministry, in light of current practices and how the main players in the tobacco industry interact publicly, sponsorships, scholarships, etc., that proper guidance be given to public officials, that they do not run afoul of the law. I'm asking that there be no assumption that it is known, because from a marketing and PR perspective, it can be assumed that anyone who sponsors something is doing so with the intention of having their brand promoted. So that definition is quite the direct and indirect and just very broad. We don't want to unintentionally bring public officials into breach, because the matter is the consequences and the practices are not in the forefront of our minds as we legislate.
Well, duly noted through chair to you, Honorable Minister. And in fact, one of the methods of facilitating this change is the transitional arrangements. The bill does provide for transitional arrangements for persons whose operations will become subject to these provisions, that they will be granted a period of time. It's stated in the bill as 6 months to bring their operations into full compliance. And there is also an exception to that, in that the provision will not apply in relation to products that have been purchased, ordered, acquired, or that have arrived in Jamaica or that are pending at least 9 months prior to the date of commencement. So there's recognition that as of the date of commencement, there will have been arrangements in train, there will have been activities that would now become prohibited or controlled under the new legislation. And therefore, there is time allowed for both commercial factors and for certain arrangements between industry and others.
Sorry.
Just putting on record that it may not, taking into account lessons learned from the past, it will require more than just the passage of time, because culturally in the jurisdiction, time is requested, time is given, and nothing happens until the period expires. It has to be accompanied by robust public education when and where it matters. Because we as a parliament will not have the luxury of saying that is not really what we intended when the law is being interpreted and people are implicated.
So what I hear you to be saying, Minister, is that notwithstanding those transitional period to which I'm going to ask Mr. Edwards to identify, there has to be some sort of a robust kind of educational campaign to bring awareness for ease of this cultural transition. Is that what you're saying?
Through you, Chair, yes. And I'm also saying that, we have to learn the lessons when we make changes, and in particular, when we implement international conventions or matters that are obligations that arise in the international context, and we're then tailor-making them to the local context. It's always helpful, or it will be helpful, to identify the existing practices, name them, so that people become aware. The definition of public official is very broad, and it is not only direct but indirect. What amounts to indirect? I'm just saying that there are too many examples now that when the provisions begin to apply, we hear it was not really how it was intended, or not sufficient thought given to what it is seeking to address. And then we run ourselves into all kinds of contention.
Minister and Senator Gill, I could refer you and your fellow committee members to some provisions that are directly on point with the matters we're discussing. So clause 37 is the one dealing with the proposed transitional provisions. That's clause 37. And then we can also look at clause 5. Clause 5 mandates a continuous, and this is not just for the transitional period, as significant as that period is, mandates continuous education and information in relation to tobacco and its implications. And that will therefore be an ongoing obligation of the ministry and the public health sector in relation to tobacco control. And furthermore, so that's clause 5 and 6. 5 and 6 deal with education and information. Now, clause 38 further, and this may allay some of your concerns, Minister Malahou-Port, in relation to an understanding of the obligations, the new obligations that are put on particularly public officials in the public sector, where power is given for the making of guidance, notes, orders, etc., that will detail the requirements, the expectations, and will essentially be a supplement to the current orders and codes that apply to public officials. So that should also facilitate an understanding within the public sector, particularly to those who these provisions will apply directly to.
One more question and expression of concern through you, Chairman. We know that currently we have numerous statutory provisions which place a duty on different office holders in government to do things, and those things are not done. And there is no accountability framework where those things are not done. I do believe that going forward, any law that places a duty on a public official to do something must also provide, whether in that law or pointing to any existing law, what is the accountability framework where there is failure to carry out the duty, and then members of the public are brought into trouble.
Mm-hmm.
One second, Mr. Stewart, you want to raise? And SG, we note your hand raised, so you will go next.
Good morning, committee members. I have listened to the concerns of Minister Malahou-Port, and I understand what is being outlined in Clause 5 in terms of the need for education. But what informed in Clause 37.1 the transitional period of 6 months, particularly considering this obligation on public officials? Could consideration be given for an extension of the transitional period in light of our current discussions? So first question, what informed the 6-month transitional period? Secondly, in light of our current discussions, can it be amended to be extended?
So, Mr. Edwards, you want to take that one?
Yes, I could, but I would also invite my colleague, Ms.
Ms.
Birch,
Birch?
to also weigh in on this. But I need to point out two things. Remember, the bill provides for a commencement date. So this transitional period applies after the commencement date.
Right.
So that when the bill is enacted, there is further provision for commencement provision to be made by the minister. Now, usually what happens in practice is that the consideration is given by the regulator, by the particular sector that the legislation relates to determine when all the administrative, or as far as possible, the administrative measures, the the financial, the infrastructure, etc., is at such a place to bring the law into operation. So it's not expected that as soon as the bill passes through the parliamentary process and that process is completed, that the law will immediately come into operation. There is deliberately included provision for the minister to make a determination as to when it's appropriate for the bill to come into operation. And during that period, there will be, well, as there has been over the last several years, there will be further awareness in the public eye that these provisions are going to become law. And then even after it becomes law, there is a further period of time that allows for arrangements to be brought into line with the provisions of the bill, and that allows for commercial transactions, things that have already been, items that have been imported or that are already in train by virtue of contracts or other arrangements. There is a 9-month transitional period in relation to that. So that I can't anticipate how long it will be between the time when the bill is passed into law, when it is brought into operation, and then the further period. But it could be a fairly significant amount of time to allow those who need to make changes to do so.
You made
The question was what informed the period. Usually, a transition period, in my experience, doesn't go much beyond 6 months, maybe 6 to 12 months. I don't usually see transition arrangements going much longer than that. Especially when.
Herein lies the concern. Herein lies the concern now, as raised by Ms. Stewart. What informed the 6 months? And you would have just represented a number of activities that may have to take place within that defined period. But you would have expressively stated that in your experience, it could go 6 months up to 12 months. Now, is there any level of consideration that, given what Minister Malahoo Ford may have represented in terms of this serious cultural shift and expectation, that we could possibly consider a longer period of transition? Because it now...
Chairman, I'd like to add to that.
Yes. Go ahead.
Again, I'm just looking at the experience in the jurisdiction. And I'm really hoping that all of us learn from how things have unfolded in so many areas, legislative areas. I find it less helpful to say that looking on legislation, transition periods usually go between 6 months, or periods do not exceed 6 months. I think the better approach is to look at what needs to be done to properly bring the new framework and paradigm into effect. And can those things be realistically done or be taken to a comfortable level within a 6-month period? having regard to who's responsible for administering the provisions. I really don't think that the better approach is simply to say that looking on legislation, the transition period is usually 6 months. That may have been a comforting approach at some time ago, but I don't believe it can be the approach at this juncture or going forward.
Well, Minister
If I may
Malawu,
clarify,
it's really for this committee to decide. What Mr. Edwards may have represented is a recommendation to the committee. It does not mean in my mind that the committee would accept that recommendation. Given what has been recommended, given what has been suggested or thought about, it is for the committee to decide what period would be most suitable in these circumstances, and make also recommendations about the different stakeholders in terms of who is going to be the overarching, who have the overarching responsibility to monitor
Chairman.
these activities.
Chairman.
Yes.
One of the benefits of televising proceedings of the Parliament,
Yes.
whether full sittings or committee sittings, is to enable members of the public who look on to gain a better understanding of how we do things.
Agreed.
So the power to decide resides in the legislature, but that power is exercised on advice in a particular context. Decisions are not just taken ultimately without numerous considerations going into what the decision would comprise. And so when proposals come, they have to be interrogated. If we're serious about going forward in a new and different way, my experience has shown that legislating international arrangements sometimes take us in going too far, and the provisions sound good, and then we struggle to implement and we struggle to enforce. And this bill is an extremely ambitious bill. I've never seen a long title of a bill so long. I mean, in a long time. And I fully support facilitating a healthy population and a healthy environment in which to live. And I, from my own understanding, have a sufficient appreciation of the harms of tobacco. And so I understand the imperatives, but it's a really complex piece of legislation being proposed. And we have to take care in ensuring that what we legislate can be implemented and enforced easier than it can be breached. That's really my general concern if I were to sum it up.
I agree with you on that point. We had Suljan, you had your hand raised?
Yes, on a different matter, but my first comment is in relation to that same transitional provision, just that perhaps there may need to be consideration for how you treat with contracts, because it's not always easy to get out of a contract within a 6 or 9 month period, depending on the terms of the contract. So I'm just saying contractual arrangements, I think, have to be dealt with perhaps or considered to be treated a little differently. I had a bigger issue, and all along when we were discussing the definition of who would be a specified public official and the fact that it included a parliamentarian, I always had some concerns, and I know that some of the concerns are represented in the report. But hearing more and more the issues about how you will have accountability and all of that, it makes me think that as it relates to parliamentarians, really, the provisions would have been better placed in the ROPA, where you would deal with political campaign donations and so on, because there is a very elaborate structure and framework that was agreed on by all parliamentarians, recommended by the Electoral Commission, the ECJ, EOJ. And I'm thinking that framework and structure is perhaps better understood by not just the parliamentarians, but the persons who provide donations. And it's no just, I really do think if you're talking about trying to have a proper framework, as it relates to parliamentarians, why not make these adjustments or suggest these adjustments for consideration in the ROPA, where it deals with campaign financing and donations. So somewhere in section 52, big A, big S, and ongoing. Because I think it would address some of the questions and concerns about the framework, about accountability, because there's no framework here. It would now be left a lot of public education. So this is a suggestion I'm making, and it would also perhaps address some of those other concerns that I have been raising throughout the life of this Joint Select Committee.
Sorry, I am being brought up to speed.
Chairman, if I may again?
Yeah, but okay, go ahead, Member Fort, Malahu Fort.
The Learned Solicitor General brought a different dimension to the concerns expressed. I know that we must complete this work, but I do believe that there are some things that just need to be rethought without undue delay. I know your goal is to ensure that we will have a piece of legislation that makes a difference and that can be implemented and enforced. The point around the cultural issues and the accountability mechanism, I do support the proposal to have matters that will impact campaign donation, advertising, probably placed in the framework of the ROPA. It's for your team to consider. It doesn't have to delay your work. It just means that after this sitting, they go back to the ministry and just look at the matter and make the proposal, and that you take it and ensure that it is proposed, proposal is made for it to be placed in a more effective framework.
Member Birch or Mr. Edwards, I'm trying to understand can you just bring me up to speed quickly, very quickly, on what the changes are being proposed?
Okay.
Chair, Ms. Birch? Ms. Birch.
Okay. So there was a concern raised in terms of clause 37, in terms of the transitional period, and whether the 6 months that we now have would be sufficient to allow for all that is required to ensure that the act will be implemented and persons can put themselves in a position to comply with the provisions of the act. So we can consider to look at a revision to determine what may be a reasonable period given the concerns expressed.
What exactly would be the cause of a delay in transitioning beyond 6 months? Anybody wants to suggest that? Because we've been engaged in this process since 2020, two, I believe.
One.
One with significant public announcements, with significant participation, particularly from those who are most affected, both those who are for and against, and including the industry. And there is an intention by policy to embark on a significant media campaign to make the public more aware. Some of that has already started just through the regular exposure of the hearings that we have here, which are live and exposed. Unless someone can cite a particular case or two that would require beyond 6 months, I must say I don't see why we would need more than that to transition to the new legislation once it is passed. That's my opinion, based on all that has transpired up to this point and the very engaging process that we have embarked on to get persons to participate in the process.
Chair?
Yes, go ahead.
If I may also just add that the 6 months is from the date of commencement, and
yes,
there is provision as yes, and there's provision, as you're aware, for an appointed day to be determined by yourself. So that period also has to be added. In that the bill, once passed, there is still provision for a date to be appointed when it is determined by yourself
right.
As appropriate. That's to be added onto the 6 months.
Right. So technically then it will be more than 6 months. Indeed, one could say that that process would have started from the commencement of this committee. Then you have the debates in the Parliament and the Chamber of Review, the upper house, and the publicity around that. I fail to see why we would want to consider this, which is what the point I'm trying to make with a lot of respect to my colleague members. We have an opportunity to review and to amend in the lower house and in the upper house. And unless the issue is a contradiction of sorts to existing legislation or some other major technicality, I want to urge members to allow the process to make any tweaking of what is required as we go forward. In this instance, though, and this is my opinion, and I respect the opinion of others, I see no reason why anyone would be in the dark within a 6-month period, having passed the legislation or determined a date from when the 6 months would commence, given that we're going through a process now that involves a lot of public exposure and education and participation. So I wouldn't be inclined to change that. Others can comment if they so desire. Member Gale.
Chair, clause 36 is specific in nature. It says every person whose operations are subject to this act is hereby granted a period of 6 months from the date of commencement of the act, to which you would have spoken that that's not yet defined and that's up to your determination. But to bring the operations of that person into full compliance. Now, in my mind, full compliance means all the instructive mechanisms that are contained into this act, to which are going to be prohibitive in nature, changes in behavior, changes in the operations. The question is, we have a tendency that we normally move when instructed. And if there's going to be a built-up campaign, sensitization, awareness leading up to what this compliance ought to be, then we could work along those lines. But we have to be clear and to be fair. Now, I see nothing wrong in having that defined transitional period and extending this 6 months to 12 months, just to be clear that we have a long runway in terms of awareness and education. Because once the rules comes into effect, we have to treat with that which is prohibitive and that what is going to cause some people to fall out of line, and the penalties that are associated with it. And in my mind, when we are making these kinds of rules, people want to be aware of their scope of permissiveness. That is only fair to them. And I think, for me, this piece of legislation is a serious cultural shift that is going to affect anybody who deals with smoking, around smoke, sell cigarette, including the little wholesales, the shops, this kind, and recreational activities is a serious cultural shift, you know. And so there is absolutely nothing wrong in making laws that is applicable, that the outturn will become associated with a cultural shift that gives people the timeline with fairness to prepare.
Okay, so anyone else wants to come in here?
Chairman?
I think, yes, go ahead, Member Golden.
I'm sorry. Chairman, I note your comments and concerns. I want to make a point, though, because there are 2 points. I know, given the period of the life of the Parliament, that we really do want to get through and complete work that has begun. I also note that, you know, it's not just a hope and a wish, but I think it's a duty of us as parliamentarians to ensure that when we do the work in the Joint Select Committee and we provide a report to either House of Parliament, that so far as it's a bill, that it is really the best bill that we can put before them. But the question of the 6-month period and your reluctance to consider expanding that, I just want to say that I don't think it is true to say that the public deliberations of the Joint Select Committee evince any idea that the public is really watching. Right now on the YouTube channel, the PBCJ publication of this meeting, there are 24 people watching. The truth is that people are not paying as much attention to parliamentary proceedings as we would want them to do. In the most robust debates in Joint Select Committees, maybe you get 1,000 people or a few hundred people. So the public education part of this is going to be huge and necessary in order to put persons on notice that they have to observe the requirements of the provisions. The Jamaica Gazette is not something that the ordinary Jamaican looks at, or most probably don't even know about. So I just want to say that, notwithstanding all of what I have said, I do agree that there are subsequent processes that will follow, that the tabling of a bill in either House of Parliament means there will be a fulsome debate and interrogation of the bill's provisions on the floor of both the House and the Senate. And so I am comfortable that we don't necessarily have to thrash out all of the areas on which we are not finding consensus, but that we can rely on the wider parliamentary group to assist with moving it forward at the relevant time. May it please you.
Thank you very much, Member. Member.
Thank you, Chair. Just to chime in, especially, and I'll be brief, the cultural context and the gravity of what we're proposing in this bill, I think we should be really very, as best as possible, lenient and allow as much as we can the attitudinal and behavioral adjustments to what we're proposing. Particularly, I had concern about it in terms of the definition of smoke, where it also includes possession. And I think if we're going even to that extent, that we must give as much time as is reasonable possible. So I am in agreement with the 6-month to 12-month time frame. Thank you.
Okay, anybody else? Let me just say, to be clear, that I'm not suggesting that I am against or not entertaining other person's views. I'm giving my own. And I will repeat that I do believe that this process, not just these hearings or discussions here, but the process of the two parliament, the upper and lower house debate, and also from based on a policy position, which requires a significant public education program, starting informally now, but will be amplified with the discussions within the parliament, should give enough time. I mean, if we are, the truth is, culture will not change in 6 months or 12 months, to be totally frank. What we need is for the rules to be instituted, people to be aware, and then behavioral change will gradually fall in over time. Change management is a very detailed science that is quite difficult to achieve. So I still believe that 6 months is enough, but if the majority of the committee feels that we need to extend it, maybe we could add a few more months and go somewhere in the middle of 6 and 12 as a compromise. So, which could mean 6 and 3 from the point at which the bill is passed into legislation. But again, I think we could also solicit the support of the Parliament in terms of discussing and debating the issue to get their views on this by proposing 6 and then allow the debates to determine on it later on. And I see no problem with that. Sorry? Yeah, I see no difficulty with that, and I don't see it as compromising the quality of what we're putting forward. I think it actually may contribute to the cut and thrust of the debate, and indeed the communication, both internally and externally, around the issue. So what is the decision? Do we go with my 6 months and allow my proposal for 6 and allow the parliamentary process later on to weigh in on it? Or do we go with 9 and stop there? Or do we go with 12?
Just to say, Chairman, it was good for us to have had the opportunity to analyze these particular concerns. And in doing so, I think we should take the opportunity in understanding and accepting what has been presented to make a movement. You would have suggested between 6 and 9. I think we could, as a committee, having heard what members have said, to be inclined to make an adjustment in the first instance, bearing in mind that some of us are going to have a second bite of the cherry when we get back to either houses of parliament. Certainly the matter may come up again, but it would be good for an acceptance of the part that we understood the challenges and the concerns, and to have made, in the very least, an amendment.
So you're supporting 9?
You know me, I would support 12, but if 9 is it, 9 is it.
All right, can we put 9 then, and then allow the debates later on to weigh in on the conversation? Is that all right? If there are no objections, then we proceed on this. Thank you very much. Proceed, please.
Just seeking some clarification, though, because clause 37 deals with 2 issues. The general
second issue I was trying to understand. What was this? Remind me of the second issue.
The second one is a contractual one. Relates to engagements, prior engagements that industry may have in train at the time of the commencement, that is 9 months. That's currently 9. So we have a 6 and a 9 month transitional period. 6 is the general, 9 is the industry commercial arrangements provision.
Can I ask Mr. Edwards, because if they have contractual arrangements, those contractual arrangements may vary in nature in terms of the duration. So it would be a little difficult for us to control that. Because if they have, let's say they have a 24-month contractual arrangement, how do we impose changes in the midst of that? Maybe we could have something to protect against that. You know, we have our own suggested timelines that we are working with, but we have no control over those who may have had contractual arrangements.
The mischief in that, though, if we were to accept that, with due respect, member, is that in anticipation of the bill, those who may want to be protected by a contractual arrangement could sign an agreement for 10 years. In that case, what do we do? Allow 10 years of outlier behavior around this issue? I think we would have to have a reasonable time, I agree, but entities would have to understand the importance of the law being implemented within the most, reasonable time. So maybe I see SG's hand up. Maybe she can weigh in on this conversation. Is there precedent for this, and what would you recommend, SG?
I had actually made a slightly different intervention, but on this specific point, just the point to note that 37.2 is very specific. It's really in relation to products which were purchased, ordered, or acquired. So it's not just about any contractual arrangement. And the issue I raised earlier is that you can have other contractual arrangements outside of this. Remember that the prohibition in relation to products goes wider. For instance, dealing with, campaign contributions and donations and so on. As it relates to 37.2, though, we recently had an experience with plastic products, packaging, and with legislation where we had to do further adjustments. I would suggest, based on that experience, that you don't put the 9-month period. I think it should be anything that was purchased or ordered before the act takes effect, not 9 months before, because you're going to, from experience, I can see that there will be difficulty. I would suggest it should be before now you could decide if you want it to be, and then I think it's correct that it should be the date of commencement, but to put a time factor as well, I think may create some challenge. And the experience is that we had to make further changes when we tried to do something similar in another industry.
I'm trying to understand what are you proposing? Let me try to understand it.
Take out the 9 months as it relates to 2. So It should be that it doesn't apply where it was purchased, ordered, or acquired before the date of commencement of the act. Right now it says at least 9 months prior to the date of commencement of the act. I don't think you should put a time to it.
I got you.
If it was done, right. Yeah, and I was just saying, as it relates to other contractual arrangements, I was trying to find another precedent because, you see, depending on the type of contractual arrangement, a 6 or 9 month period may not be sufficient to change that contractual arrangement, and it also depends on the contractual arrangement. So I'd made that comment earlier that I thought that there needed to be just something to address other contracts, because I realize that this is limited. But I don't have a suggestion right now. So I would say you go with it, and there is still opportunity at some later stage if we think there needs to be some adjustment, that those proposals can be made at another place, at another stage.
I like that latter comment. Can we apply that principle to some of the other things that are controversial? Thank you very much, SG. I agree with her suggestions, so we can make that change unless there are comments from any other member. If no comments, we'll accept. So you want to just rephrase that, or yourself? It's just a deletion. Okay. All right, continue.
Thank you, Chair. So we're looking at Clause 8, limited interactions with the tobacco industry by a person who has responsibility for tobacco control. Clause 9, prohibition on partnerships and endorsements of the tobacco industry, acceptance of voluntary contribution, etc. And Clause 10, assignment of duties by a public body and making of disclosure, etc. In respect of Clause 8, members of your committee express concerns that persons who act on behalf of or for the benefit of a public body which has responsibility for tobacco control would be held criminally liable for interacting with a person in the tobacco industry. We felt that the intention of such interaction, although in the furtherance of a business activity, would have to be explicit. One of the concerns that the Attorney General expressed with the clause was that it appears to infringe on certain fundamental human rights, such as the freedom of association and equitable treatment by a public authority. Members of your committee were advised that the wording of the provision meant that the tobacco industry would be treated different from other industries, such as those relating to marijuana and alcohol, that created similar dangers as the tobacco industry. It was pointed out that consideration had to be given to whether it could be established that the distinction was demonstrably justified in a free and democratic society. Your committee also considered the wide reach of Clause 9 to include all persons employed to a public body, irrespective of their level of employment in the public service, and public officers being subject to criminal sanctions for contravening the provision. With regard to Clause 9.3, your committee considered that public employees might unknowingly invest in the tobacco industry through a broker, and your committee did not feel that they should be penalized for not being aware of such investment. In relation to Clause 9.4, your committee considered that a low-level staff member in the public service who was not directly involved in tobacco control policies might have a retail business that sells tobacco products or related products to supplement his or her salary, and it would be excessive for him or her to be criminally liable for contravening the provision. Members of your committee were advised that paragraph 10 of the guidelines for the implementation of the Framework Convention on Tobacco Control states that in order to prevent conflicts of interest, there should be clear guidelines for public employees and officials regarding their interactions with the tobacco industry. Your committee noted that there is the potential for compromise if public employees have an interest in the industry, since the industry might have its own agenda that conflicts with public policy on the restriction or control of tobacco products and tobacco-related products. Despite this, your committee felt that the provision should be more targeted to specify public employees who are involved in tobacco control policy. It was observed that a person employed to a public body could be found criminally liable for breaches such as accepting a scholarship from a tobacco company to attend an educational institution. We express a view that public officers should not be criminalized for accepting a scholarship. However, it was noted that there could be an unexpected loyalty by persons who were being sponsored by the tobacco industry, and its products will appear to be less harmful to them. Members of your committee noted that Clause 10 provides for a disclosure requirement for persons who seek employment with a public body.
Before we move to Clause 10, Chairman, There is a point that I raised in the chat that I just asked that it be addressed at this stage in respect of the proposed amendment to clause 9.
Can you repeat that point, please, for the benefit of?
I see, Chairman, a proposal which is placing a burden of proof on an individual. And I just ask just to seek some clarification from the Learned Solicitor General in respect of this provision in light of the changes that were made to that area of the law when the charter was enacted. And what I see is raised from time to time and most recently in the public domain.
To you, Chair, if I may just give a preliminary response to Minister Malahou's report. What I'm now reading is a historical development of the bill and the deliberations. The members of the technical team, in light of concerns that have been expressed, particularly in the last sitting, there have been some significant changes to what I just read. So the bill as now being proposed does not actually have that provision that Member Malahou Ford refers to. And there have been some deletions and adjustments. So maybe, Chair, if I could continue going through and referring to the draft as it now stands, some of the concerns may have been addressed in the rewording that is being proposed.
Member, can we do that and then you can come back to the point just in case?
Yes, Chairman, but just to note that what I referenced was what I received yesterday, communication in respect of proposed changes.
Right, so it has been a moving work in progress, so maybe it will be addressed as suggested by Mr. Edwards. So just make a note and Mr. Edwards proceed, please.
Thank you. Members of your committee noted that Clause 10 provides for a disclosure requirement for persons who seek employment in a public body and the need for them to disclose current or prior occupational activity or any other affiliation with the tobacco industry in order to determine if a conflict of interest exists. Your committee also took note that the provision also provides that a person employed to a public body should not engage in any occupational activity that might create a conflict of interest. Having considered that the provisions of clauses 8, 9, and 10 might be excessive, your committee recommends that these clauses be deleted and new provisions be inserted to take into consideration aspects of regulations 22, 23, 26, 27, 28, 31, and 32 of the Kenyan Tobacco Control Regulations. Your committee was informed that the Kenyan regulations was a more carefully designed scheme that achieves the objectives of the WHO FCTC, particularly Article 5.3, and provides a more focused scheme to address limiting interactions with public authorities and public officers and the tobacco industry. Your committee felt that the new Clause 8 should make provision for the interactions of specified public bodies or specified public officials with the tobacco industry. The new Clause 9 should address the avoidance of conflict of interest, certain arrangements or engagements between public officials or public bodies and the tobacco industry, and that the new Clause 10 should address disclosure of prior or future engagement with the tobacco industry. Your committee felt that the following should be considered for the new clauses. And I'll now read the Clause 8 as had been proposed. Limited interactions with the tobacco industry by a specified public body or a specified public official. It should be a requirement that a specified public body or specified public official only participate in interactions with the tobacco industry to the extent strictly necessary for effective tobacco control and enforcement of relevant laws. Specified public officials should not participate in any interaction consisting of a meeting with the tobacco industry unless there is joint participation with at least one other specified public official. Specified public officials should be required to state in writing to the appropriate authority, which is a defined term, within the specified public body that they are employed or engaged, that any interaction with the tobacco industry will not imply an endorsement of tobacco industry practices, and that there will be no relationship, collaboration, or partnership arising from the interaction. Your committee supports that the written notification should be acknowledged by the industry and that this must take place prior to the commencement of the interaction. A specified public official participating in interactions with the tobacco industry should be required to prepare a formal record of the interaction and submit same to the specified public body he or she is employed or engaged within, and on the request of the appropriate authority. Your committee recommends that the regulations that will be developed to govern tobacco control could prescribe a standard form to be used by specified public officials to record their interactions with the tobacco industry. Your committee is of the view that a section of the form should detail where the interaction with the tobacco industry takes place. Further, a specified public body should ensure that any interaction with the tobacco industry, as far as practicable, takes place in a public venue determined by the specified public body, and that the interaction should not take place within the facilities of the tobacco industry, except where necessary in the course of the enforcement functions of authorized officers. Finally, a specified public body should not accept any funding or enter into, support, or endorse projects or partnerships of any kind with the tobacco industry. A specified public body should not accept from the tobacco industry any offer of hospitality and proposals, drafts, or offers of assistance towards the development or implementation of tobacco control policy. It should also not accept any financial or resource contribution or become involved in or endorse in any manner any initiative, campaign, or program directly or indirectly related to tobacco control, including but not limited to youth access and education programs and public education campaigns. So that is clause 8. Now clause 9.
Clause 9.
Agreed.
Before you go to clause 9, because I'm trying to jog my memory. The second bullet point first, specific public officials should not participate in any interaction consisting of a meeting with the tobacco industry unless there's a joint participation with at least one other specified public official.
Yes.
Is it that?
I mean, you mustn't meet alone.
You must meet alone.
Right.
But is it parliamentarians can meet together?
Sorry.
Well,
I'm just questioning. So would the intent be satisfied if one parliamentarian is going and say to another parliamentarian, accompany me?
Well, it would be just a specified public body.
Specified public official.
And it's for a discussion.
And that's defined.
The guidelines around the discussions are clear. It's for enforcement of the laws. And what it's suggesting is that it should be more than one person.
Right.
So that's my interpretation of it.
But if more than one attends
To discuss within a particular framework. That can't, you can't disjoint both.
Okay. I just wanted to answer, so this would be a formal kind of setting. That's what it's explicitly.
That's the interpretation. Yes.
The second one is where it spoke to a specified public official participating in interactions with the tobacco industry should be required to prepare a formal record of the interaction and submit same to the specified public body he or she is employed or engaged within, and on the request of the appropriate authority. I'm trying to understand whether it is specific based on the request of the authority itself, or is it an obligation that once you attend, you must put forward this formal report? Because it seems, in my mind, a little joined.
Mr. Edwards, you want to comment on that?
Yes, Chair. I'm just trying to find the provision.
One, two,
a specified
three,
public
the fourth bullet
official
point in the report.
Okay. Yes. So, Senator Gill, through the chair, what was your concern?
My concern is once you go to this formal arrangement, is it that you must put forward this report, or is the report required to be submitted upon the request of the appropriate authority?
You are required to prepare a formal record and submit it to the specified public body. Yes.
Yeah, well, you say upon the request of the appropriate authority. Suppose the appropriate authority did not request it.
No, you're still required. You're still required. You're still required.
Okay.
Yes. Yes. And by the way, the appropriate authority is colloquially your boss. I mean, the person who is in charge of the body that you work with. Yes.
But I don't know if there's a possible gap where if it is not requested, someone can say, but you never requested it.
Okay, Katie, Mrs. Birch, you want to come in here? It's on the same issue?
Yes, Member Gale. So, in reviewing, in light of your in light of your comments, it could be interpreted that it's only on request that this record is to be provided. Pardon? So this is page 14 of the updated tobacco bill that was circulated. So perhaps the committee could consider whether in the last line the words and on request or on request be deleted, so that it is clear that they shall provide this record and it's not only just on request.
Yeah. Okay.
No, it's two things. If I may, Chair. Thanks, I thank Ms. Birch for that. But it's two things. It's a double obligation that is being put on the official. The general obligation is to submit this information to the body that you work with. But then there's a further obligation that if the person to whom you directly report, so it may not be the same. So there's an obligation to submit it to X authority, meaning the body. But there's also an obligation that if the person to whom you directly report requests this record of the meeting, that you submit it to that person. So the report to the appropriate authority, your direct head, for example, is not required except on request of that person.
I thought it was the other way around. I thought it was the other way around, Mr. Edwards.
No, Chair. It's that you submit a report to your organization.
Right, and then upon request by an oversight body, then you submit,
no.
but you're not. It's not automatic if requested.
Exactly. That is not automatic.
Is that your interpretation of it, Ms. Birch?
Given the concerns range, I see where how it is currently drafted could create some confusion. So
I agree.
I think that because as you had indicated, you're going to submit to your public body, but who would you submit to within that specified public body? Yes. So if there is a specific division that deals with that, but you could also submit to be mandated to submit it to your appropriate authority, which is your boss, the person who you directly report to.
So that is on the request of the individual now, your immediate boss.
Right. But given the concerns raised to say whether it may be interpreted that it is not obligatory, we could be clearer for clarity to remove on request. So it is you're submitting to this public body if there is a specific division to submit this declaration to, this report to, and to your boss.
You see, what I want to be sure and to be satisfied on is the obligation on that public official in the event that public official attends any sort of meetings or forum. What is the obligation? To ensure that the individual would have satisfied in the first instance that obligation because they know what they ought to have done. And then know that second part to say, if your boss now requests it, the same report, you're going to send to your boss. But how it appears here, drafted, written, it appears joint to me. And why I ask it is that I want to make the distinction in terms of the accountability. Because if the appropriate authority becomes aware, then the appropriate authority has a responsibility also to demand or to request that report. So we just want to be clear in terms of what persons will be held accountable for and what actions are required.
But Mr. Edwards, if you are the problem is that both interpretations suggest two different things. So you have to decide exactly what the intention is. So in your case, you're saying that there is an immediate supervisor, to use layman's language, having had a meeting, you have to report to. But there's an authority beyond that that may or may not request a report. And upon request, you submit to them. That's a very different interpretation. And that's the interpretation I get from the document as is now, as opposed to suggest that you have to report to your immediate boss, in this instance, and to an authority automatically once you have that meeting. So I'm just trying to understand, is there in the bill the intention to report automatically and then upon request to a secondary authority, or is it one of the same?
That is so. That is so, Chair. In other words,
that is so, I don't... Yeah, go ahead, sorry, go ahead.
No, what you say is correct. In fact, there is what you call the local reporting right at the local.
So I don't think there's a need for an amendment, Ms. Birch, based on the interpretation that is quite clear that you have an immediate automatic reporting, having had a meeting, to your immediate boss, supervisor, whomever that designated authority, internal authority is, and then upon request, that report could be made or should be made available to an overarching authority. That's what I'm interpreting the...
Chairman, if I may.
Yes.
What is, and just forgive any gap that I have, what is the nature of this report? Just to simply say that you have met? Just remember that reporting obligations are quite onerous, and many times they are not complied with or sufficiently complied with. And the reporting obligation is with a view to what? So, two questions primarily. What is the nature of that reporting? What is it expected to say? And what is the consequence for not reporting? Or the report having been made, what is it to be used for?
Through you, Chair, the intent,
Go ahead.
Minister Malahu Fort, is that, and it goes to accountability, is that one, there
Mr. Edwards,
no...
Sorry to intervene, but in addition to that, if you could also, because it is in keeping with Minister Malahu Fort's intervention, where you said we are of the view that a section of the form should detail whether, is it whether or where the interaction of the tobacco industry takes place?
Where? I had corrected it in speak.
Yes.
Senator Long. It's where.
Okay.
Where.
Mm-hmm.
Mm-hmm. Yes, so the intention is in furtherance of accountability and full disclosure, that there be not just information that the interaction took place, but some details, and this can be further fleshed out in guidance to the public sector, details as to what actually transpired in this interaction. So it's two things. One, the fact that there has been an interaction / meeting between X official and Y member of the industry, or X and Y, two persons, two officials at least, and industry, and what took place during that interaction. Because it also is protective. It's also intended to protect. It's also intended to protect the public official. This record keeping. Yes, sorry.
Again, you have to forgive me if only because of experience. We often legislate things that just make sense. When you say with a view to account, ultimately what are you accounting for, and how will someone be held to account with this mechanism? It's only because I see so many times where we have legislated and the things sound good, but for practical purpose, it really, nobody's been held to account. And the burden that is created, it's easier to not comply than to comply. So ultimately, what is expected? We should never legislate anything that does not have a practical purpose. All right, so so you disclose, and you're disclosing for what purpose? And if you don't disclose for what purpose, what ultimately, because I'm not getting a sense of what that ultimate accountability mechanism will look like practically, not theoretically.
Well, the context within which this record will be made is in the context that there is an understanding, there's an expectation that there is limited, there's supposed to be very limited and only very necessary interaction between industry and the public sector. So in that context, if one is going to interact under that umbrella, there should be some justification. One of the purposes of such a record.
Would it be more helpful to indicate what the interaction should look like? Because again, when government regulates, whatever restrictions that you place on any industry, there will inevitably be some interaction between government officials and industry. Anything that is present in your jurisdiction, and particularly in Jamaica's cultural context, small jurisdiction, and I don't have to spell it out at this time. What exactly is prohibited?
No, but I think,
more importantly, when you are interacting, what can you lawfully interact around?
Remember, if you read the previous clauses leading up to this point, it specifically states that the interaction has to be around issues related to the enforcement of the laws, the provisions around for the particular entity or individual. So you're already bounded by what precedes this clause. You are going there for a specific reason. It's not to have a drink. It's not to. It's not that they just pounce upon you or you on them. It's for a very specific purpose that is guided by the legislation. And what we're requesting is that the minutes of the meeting be recorded. It's no different from a board meeting of some kind that you record the minutes.
And people don't have drinks when they meet for meetings, Minister.
Okay, that was just, that was all right. So I really want to I think we have to close at midday. Unfortunately, we have to have another session. And there are some dates that I'm trying to work out here for a quick session because really would like to get the report finalized. So I ask your indulgence and your sacrifice for another session at least. But just to close this point, I think the key to determining what the wording is whether or not there are two authorities we're reporting to. One as a compulsory requirement, another on request. Which is it, Mr. Edwards and Ms. Birch?
Just before the answer, Chairman, the key is really to be clear what it is, what you're intending.
Right, that's the point.
That's the policy intent.
Well,
right.
I appreciate your legal mind, which I don't
No,
have.
it's not legal. It wasn't meant to be a correction per se, but just a clarification.
Right, I appreciate that. So can I find out what's the purpose? What's the intention?
So the intention is to have this record of what the meeting is about for transparency purposes.
Right.
So as had indicated, especially for specified public officials, which are the officials which are involved in developing and implementing tobacco control policy, you want to ensure that their interactions are limited to enforcement, tobacco control and enforcement.
That point is taken, Ms. Birch. And so, the issue is, are there two authorities, the immediate supervisor, for want of a better word, manager that you have to report to, and then another that may be an authority that oversees the process where you report on request, because that is what this is saying here.
So as it is written now, you are reporting to the public body you're employed within, and on request, you may submit the report to your supervisor.
Oh, okay.
If I may, Chair.
Is the supervisor, just sorry, Mr. Edwards, is the supervisor meant to be other than the public body that you're employed to? I'm not understanding. Oh. What is the difference?
And I think I may have to confess to causing some of the confusion, because the next level, which I think is what Chair is trying to get to, is really not the immediate supervisor. I need to clarify. The next level is really the individual or entity that that has ultimate oversight of the official conduct of the person. So that could be, in the case of a public official, that could even be a service commission.
That's the point. Not That's just exactly the point I was making. So
yes, I realize that I didn't make that clear. Yes.
Okay. So if
at this point we shouldn't be guessing and spelling, because we do know what the reporting framework is.
Right. So
we do know what the public service regulations say. We do know what the civil service establishment orders say. I mean, this is a kind of cross-linking that is required for clarity.
Well, I think it's a good exercise, Madam Member. It ensures that we're all on the same page. So I wouldn't be too hard on Mr. Edwards, but I get the point you're making. So what I'm saying then, if it is that there is an immediate compulsory requirement for reporting, Ms. Birch, in the first instance, and then there's a secondary authority that on request you are required to report to, then the wording there is appropriate, I think. You understand? Unless they are one of the same, then the adjustment would be made. So Mr. Edwards is suggesting that it's a separate authority. If that is the case, let's just hold it at that.
Chair,
Yes.
May I make a
yeah, Chair,
suggestion,
in some cases there may not be a separate authority because depends on, you see, the wording has to be general to cover
no, you're
the
confusing me, Mr. Edwards. You move from
May
one
I make a
confusion to the
suggestion,
next.
Chairman?
Yes.
May I make a suggestion?
Go ahead.
Since the meeting will be terminated shortly, one of the biggest areas we have in public administration in this country is around just reporting obligations, the burden that it creates. We often we're enticed to this idea that everybody must report, and it's a good thing. But if you look at the problems that we have right now with reporting obligations, they are many, 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 many. And the provisions seem to lack some clarity. So if the specified public official has interacted and is mandated to report to whom in where that person is employed. So in the case of a parliamentarian, for example, whom do you report to? The Speaker of the House? Just asking. All right? Because remember, the definition includes the parliamentarian. And then who would be the second tier person, and who then has the obligation? The same specified public authority, or if, for example, it's the speaker to report it up? I'm not sure that that is clear.
Okay, tell you what, given that we're over the time by 3 minutes, and we will have to meet again at a date that will be announced shortly, can we hold on this point, seek some clarity on it, have some discussion, consultation, and then be a lot clearer? It seems to me that the decision is really around whether it's one or two authorities, and in which case one is compulsory, one is on request, and if it's a case where it could be either or either, then the wording would be adjusted appropriately. But I think we need to be clear on it. So I'm going to ask Ms. Birch and Mr. Edwards to seek the necessary consultation. If all are agreed on that, I would like to propose that we suspend or end this meeting, this session, and suspend the discussion for another date. But before that, is there any new business? Number 7 on the agenda. Any new business? No, I didn't think so. Any other business?
So move for the adjournment.
Sorry?
So move for the adjournment.
No, hold on. Not so fast. Given that you delayed us, and quite constructively so, for a while, give us another minute or two. I'm going to ask that a date for the next meeting. Okay, we don't have a specific date, but within the next 2 weeks, we're going to try and set a date. We have a lot of competing interests, that's the thing. I am ready right now. If you want to do it next Wednesday at the same time, 9:30, I am available. Okay, as soon as I confirm it. All right, so we're going to get that confirmation today and circulate. And I'm going to ask members, please, to the extent that you can, let's try to wrap this up. Yeah, Wednesday the 28th, I think it is. But I think the parliamentary staff wants to be sure. So we will contact you on that. So can I have a, well, first of all, thank you very much, ladies and gentlemen. I thought that we had important conversations. So I have no regrets. We just need to ensure that we get back together as soon as possible to continue through to the completion. Can I have a motion for adjournment? So moved by Member Malahoo Fort, seconded by Member Gale. Thank you very much. Have a great rest of the day.
Thank you, Mr. Chairman.